So good evening, everyone. If you weren't here earlier for our showing of the report, welcome to the University of Pennsylvania Carey Law School and to an event that is central to the foundation of the Center for Ethics and Rule of Law here at Carey Law School. It's one of the issues that Professor Finkelstein, our founder, has worked on since the inception of the creation of the center. My name is Chris Welsh. I'm Executive Director of the Center for Ethics and Rule of Law. The foundation of our center was in part, again, motivated in response to the Bush administration's interrogation and torture program. So we're happy that all of you, and especially our distinguished panelists, could join us for this event. Before I formally introduce our moderator for tonight's discussion, Professor Finkelstein, I want to take a minute to briefly discuss CERL and what we do. So what is our mission? We're a nonpartisan interdisciplinary institute dedicated to preserving and promoting ethics and the rule of law in national security, democratic governance, conflict, and war. So what does that mean? How do we actually do that? Well, first we educate the public about issues of importance in ethics, rule of law, and national security, and we do that through events like this. Events like this that all of you are here present for, but also that we're live streaming and recording and we'll put out to our large audience of people that are interested in the work of the center. How else do we do that? We educate students. So we have a variety of students that work with us throughout the year, and then we also have a summer internship program where we expose students to the issues of ethics, rule of law, and national security, and to national security professionals in the hopes that we can instill ethics and rule of law values in the next generation of national security leaders. We influence policy. We draft policy papers, hold briefings at the Pentagon, and try and influence people in one of our policy papers, when our first was on the interrogation and torture issues. And then we advance academic thought. So we have a volume series with Oxford University Press, Ethics, National Security, and the Rule of Law. And the most recent volume was published, I don't even think it was published in the United States yet, but it's available for sale outside of the room here. It's Interrogation and Torture, Integrating Efficacy with Law and Morality, and one of the editors is on our panel. Yes, Claire has a copy right here. So if you're interested in learning more about the center, you can always talk to me. Again, Chris Welsh, I'm the Executive Director, or I will introduce also our founder and faculty director, Claire Finkelstein. Claire is the Algernon Biddle Professor of Law and Philosophy here at the University of Pennsylvania Carey School of Law, and she is the co-editor of our series with Oxford University Press, and also is, again, the founder of the Center for the Ethics and Rule of Law back in 2012, and in large part because of the issues that we'll be discussing here today. So we're honored to have such a distinguished panel here with us, and I'll turn it over to Claire. Thank you.
Thank you so much, Chris, and thanks to Chris and to the rest of the CERL staff for making this evening happen. To our panelists, and once again, let me also thank Amazon for partnering with us and the Middle East Center here on Penn's campus for co-sponsoring this event as well. I'm really delighted to have this particular group of panelists here with us to discuss this riveting and very important film, especially because with this group it really feels like a family reunion. And in one sense that's exactly what it is, because first to my right, let me introduce Catherine Eben. Catherine is an investigative journalist, a Fortune magazine contributor, an Andrew Carnegie Fellow. Her articles on pharmaceutical counterfeiting, gun trafficking, and coercive interrogations by the CIA have won international attention and numerous awards. She has a new book out, A Bottle of Lies, and she is stopping off here almost on her way to India to do the Indian book tour. It's about the pharmaceutical industry and the generic drug industry. She also happens to be my sister, so I'm very, very pleased and proud. Then to her right, Dr. Steve Xenakis. Steve is a CERL Executive Board member and psychiatrist with many years of clinical, academic, and management experience. He retired from the U.S. Army as a brigadier general in 1998. He is actively involved with, in addition to CERL, with Physicians for Human Rights and Human Rights First, and is the only retired military general and physician to speak out publicly against torture and the involvement of healthcare practitioners in torture. He has been very active with Guantanamo defense team and is consulted widely for his knowledge on PTSD and other related issues. Alka Pradhan, to his right, is a lecturer in law at the University of Pennsylvania, Carey Law School. She is also a human rights counsel at Guantanamo Bay Military Commissions, representing some of the 9/11 accused. She was previously counterterrorism counsel at Reprieve, where she represented a number of Guantanamo Bay detainees in litigation involving habeas corpus claims and conditions of detention. She is a great expert on the challenges of representing the defendants in Guantanamo Bay, and we're delighted that she could take a brief break from her busy practice schedule. She will be off to Guantanamo Bay already again next week, if not sooner. So we're delighted that she could be here with us today. Alberto Mora, who is also a member, I'm proud to say, of the CERL Executive Board. He is the current director of the American Bar Association's Rule of Law Initiative. From 2001 to 2006, Alberto served as the general counsel of the Department of the Navy. He has broad experience in the law, government, industry, and in academia. He led a 3-year research program at the Harvard Kennedy School to assess the policy costs and consequences of the U.S. use of torture in the war on terror, and taught a graduate level course on this subject. And most importantly, as you will see from the discussion, he has deep knowledge of the subject and was involved in very early on in trying to put a stop to the program as it came out, and is really known by all of us who work in this area as a hero in this domain. And last but certainly not least, Mark Fallon is also a member of the CERL Advisory Council and the author of an incredible book, Unjustifiable Means, the inside story of how the CIA, Pentagon, and the U.S. government conspired to torture. Mark spent more than 30 years in the national security arena, including as a senior executive with the Department of Homeland Security, Deputy Assistant Director of the Naval Criminal Investigative Service, and Deputy Commander of the Department of Defense Criminal Investigation Task Force, established under President Bush to investigate al-Qaeda terrorists. His book, Unjustifiable Means, tells the story, and he will tell some of it here tonight, of how he, as an investigator assigned to Guantanamo, was pushed aside in his objections and his attempts to resort to the methods of interrogation that he knew were likely to be most effective, and what he did to try to put a stop to the torture program. So I'm delighted to have you all here. Thank you so much for coming, and I'm really pleased that we can have this discussion on this riveting film. I'm going to start by asking each of our panelists a question that will reveal their connection with this subject, and then we'll mix it up a little bit more and discuss very freely some of the issues in the film and the broader issues that the film raises. So, Catherine, it was your story in 2007, published in Vanity Fair, and I want to say 2 years before the New York Times or other major papers got on to this story, that revealed the role of the two psychologists depicted in the film, Mitchell and Jessen. Now, this wasn't your area. You were working in the healthcare industry and reporting for Vanity Fair and for many other magazines and papers on issues in the healthcare practice. How did you come onto this story, and what made you realize the sort of blockbuster story it was going to be?
So it was 2006, and I was contacted by a researcher at Physicians for Human Rights, and he knew of my work. He recommended that I look into what was a very controversial task force that was run by the American Psychological Association. And that task force came up with a set of guidelines that permitted psychologists to participate in coercive interrogations. And what was striking about this task force, it was called the PENS Task Force. What was striking about the task force was that this left psychologists alone among any kind of medical practitioners in being permitted by their professional organization to participate in these. And the question was why? And he wanted to come see me. He had a group of psychologists that he wanted to bring who wanted to talk to me about what had happened on this task force and whether somehow there was some sort of quid pro quo. Their theory was that there was a quid pro quo, that if they gave cover for their members to participate in coercive interrogations, in other words, to justify and serve as cover to be able to say we're not doing harm in these inquiries, that somehow the Pentagon was going to grant them prescribing rights. And I think that's why they came to me, because I had done a lot of pharmaceutical coverage. So they came to visit me. They brought me hundreds of pages of documents from this task force. But as I reviewed them and mulled over them, I didn't see a smoking gun. I mean, there was no sort of embedded quid pro quo. I began reporting off of these documents, contacting people, and I didn't see it. But I cast a wider net, and I began talking to a lot of people, medical practitioners, who had written opposing these coercive interrogations. And these names came up, Mitchell and Jessup. Nobody told me what their role was, but I heard their names. I became very interested in them, so I set out to find out more about them, found out that they had been SEER trainers with the Air Force. And I remember very clearly that in order to get as much information about them as possible, I tried to get any kind of records I could related to them, but the problem was James Mitchell had a very common name. And I wanted to find out his middle name so I could really drill down into records. And it took me a long time. It took me weeks. And I remember actually distinctly the day when I found out his middle name was Elmer, which was very useful because it was so particular. Once I had his middle name, I went into state business records, and I found, it was interesting, about 3 months before 9/11, he had left his Air Force training job, and he had incorporated these sort of psyops shops that had actually sort of creepy names. Knowledge Works, Mind Wizard, What If, LLC. I became interested in these companies. And then what was interesting is that for Knowledge Works, I found a record which said, we're shutting this company down, and the participants involved in this company are moving out of state. And the date was March 28th. And as long as I've been an investigative journalist, I've always done every single one of my stories with a timeline. And what was interesting was that Abu Zubaydah had been captured in Pakistan the day before. And from that detail, I was able to begin to construct their role as architects of the coercive interrogation regimen. The other thing that I was able to do is in sort of digging into as many records as possible, I obtained records from an APA conference. I had got an attendee list. And the APA conference was sponsored by the CIA. And on the attendee list, there were Mitchell and Jessen, who were listed as CIA contractors, which is something that actually Jane Mayer had not been able to confirm for the New Yorker.
So let me just get this right. So we're talking about March 28th, 2002.
Yeah.
Right?
Yeah.
So, and what did you think when you saw that they had closed up shop on that?
Once I put it in my
Franchise.
timeline and saw that Abu Zubaydah had been captured the day before, it seemed to me that this was highly significant. And in fact, as this movie makes clear, and I was struck watching it again, this was set in motion before any of the detainees were even captured.
Right, and that was going to be my next question. We'll drill down on this a little bit more, but I take it if they moved so quickly after Abu Zubaydah was detained and brought in, it's because that relationship existed already.
That's right. It already existed. But, the other, I would just say this, and I know there's move on, but the other facet of my reporting that was really striking is as somebody who had done a lot of healthcare journalism, what became clear to me through interviews is that Mitchell and Jessen didn't have any data to show that these interrogation methods were effective. And colleagues who I had contacted always talked about how whenever they encountered Mitchell and Jessen, they were always asking them for data, and they said, the data's coming, and it never came.
Now, I just want to be clear. It was your article that Scott Burns bought the rights to make this movie, right? How far did it come from your article to the resulting movie? I mean, there's a lot in there that sort of moved away from the original Mitchell and Jessen story, especially the second half with the debates around, with Congress and so on.
Right.
Were you surprised when you sort of saw the evolution of the movie?
I'm never surprised because when you dig into projects like this, where you wind up is rarely where you start. But my understanding is that, one of the things that interested Scott Burns very much in my expose was this depiction of Mitchell and Jessen, which was accurate as the sort of used car salesman of the enhanced interrogation world. That they were, sort of selling a bill of goods to the CIA, which wanted the solution to the operational challenge, wanted to be able to say that it was their efforts that were leading to information, and that they had sold a sort of voodoo science to the agency. And so he was very interested in Mitchell and Jessen, but the more that he got into it, I think he really decided to run with the Senate report story. But obviously Mitchell and Jessen are huge characters in that story.
So that's voodoo science is the perfect moment for Steve Xenakis to come in and tell us a little bit about this voodoo science because you're very aware of the history of how psychologists got involved in this, and there was several references to Marty Seligman and the theory of learned helplessness. Marty Seligman, of course, is a very successful, well-known psychologist at my own institution right here at University of Pennsylvania, who did path-breaking experiments with dogs. Can you tell us a little bit about those experiments and how they led in the minds of Mitchell and Jessen to where they came out?
Sure. Let me just start that you heard the description of the experiment in the movie, and I think that's how we all learned about it. I did my training in psychiatry in the 1970s. I trained at an Army Medical Center in Presidio, San Francisco. We were exposed to this research, and particularly as we were trying to work with patients who came back who were depressed. I mean, this was the Vietnam era. We had a number of people returning from Vietnam and that time we didn't even have the label of PTSD. That didn't come into the nomenclature until about 1980 with DSM-3. But we knew we had these individuals who were coming back from the combat zone with stress reactions, depression, and at times psychotic episodes. And so one of the ways that we were trying to understand what the problem was to look at the research that Professor Seligman had published around the dogs. I'd have to say that it did not particularly convince us that the symptoms and the problems that these individuals was having could be attributed, although there was some you could see that there was some linkage there. Let me follow up that from that, though, there was very little that came out following it publications in terms of treatments that were going to be, we would be able to formulate based on what the findings were of these experiments that perhaps explained the problems in mood and thinking. At the time, and I cannot say that in the work that I was doing, as I learned more about it, that you could see that there would be, with any kind of confidence, a tactical or technical way that you would get good interrogations. Now, that in part was also an understanding, because in the 70s, and particularly in San Francisco, there was a lot of activity around consciousness and levels of consciousness and what we would learn. I mean, we were trained to do Amytal interviews, barbiturates, to use them. We had access to hallucinogens, to LSD and ketamine. There was a whole host of Army doctors that were involved with the use of LSD in the late 50s at Aberdeen Proving Ground. One of my fellow residents, his older brother, was in fact the person who was in charge of doing that experiment. I personally, when in doing my work, I was trying to understand schizophrenia, had access to a complete sensory deprivation room that was annex to Letterman Army Medical Center. So we had a lot of exposure to this. And I don't think that any of us who came away from that felt much confidence that in exposing a subject to any kind of sensory deprivation, to any kind of stress, to any of these drugs that altered consciousness were particularly going to give us useful and valid information.
So let me just ask you a question about that. You were not in doubt about the ability of, say, interrogators using these techniques to induce a state of learned helplessness. Your doubt was about whether or not, if you did induce such a state, it would give you reliable, actionable information.
Right, and I wouldn't even talk. We talked about it as altered states of consciousness. Professor Seligman, with these dog experiments, talked about it as learned helplessness. In other words, that these dogs, and we were not quite sure exactly how it applied and described what we saw in humans, that these people were unable to act with intent and in a way that would be protective. What we saw were altered states of consciousness. We saw confusion. We saw paranoid thinking. We saw delusions. We saw misperceptions. And so, because that was the picture, that was the kind of mentality and mental state that we encountered, it really led us to doubt seriously that there was any good information that was going to come out of that.
Now, let me just ask you, though, I mean, understanding the phenomenon of learned helplessness as a real phenomenon has had other applications, some of them very beneficial, such as in the case of battered women. So where defense counsel have been allowed to call expert witnesses to say that a battered woman or battered spouse of any gender who killed in a state of repeated abuse over many years and repeatedly calling the police with no result might be in such a state of altered consciousness. And that has resulted in some of those cases being viewed more leniently. Do you sort of credit that use of this data, or do you think that it's problematic
there's
across
plenty
the board?
of data out there that put individuals in situations where literally they can't see daylight, and I don't know if I would attribute it to Professor Seligman and my helpers. We see this with our veterans. I mean, who have come back. I mean, look at I use it to explain many of the individuals I've evaluated, and some who've survived very serious suicide attempts. I mean, they're suffering with anxiety, PTSD, depression, headaches from traumatic brain injury, pain from other injuries that they've got, sleep problems. They don't see any daylight in their lives. They don't see any options, and the only thing they can do is kill themselves.
Yeah.
Is that learned helplessness? Would I attribute that to Seligman? And well, I mean, it explains it in part.
A loose relation.
But it's really the stress that these people are on, and there's a huge literature out there about stress.
Now, I'm going to move on in just 1 second, but one more question about this. The American Psychological Association continues to grapple with this history. Do you think that the APA has come out to a place where, they've got their values, priorities, and understanding for the future straight, or do you think that the APA is still conflicted and unsure what the guidance should be?
I think they're more unsure than not. I don't think they're clear on the rules. Psychologists are really an amalgamation of professionals. I mean, we all as physicians who are in clinical practice and licensed really subscribe to the Hippocratic Oath and the first principle, first do no harm. But amongst the psychologists, there's really a variety of people. There's researchers, there's educational, there's consulting, there's operational psychologists, and there are clinicians. There's really a whole group of them that have within their particular sector, have a practice that they will engage in. And I don't see clarity amongst the psychologists in terms of what they do and why they do it and how it has to do particularly with if they're going to do an experiment that may be harmful, what the rules are going to guide them.
And the film was very interesting in drawing just the contrast that you mentioned, because at one point the physician's assistant says, well, the physicians are not allowed to participate in this from the direction from the American Medical Association. But there the APA had sanctioned the engagement of psychologists.
And that, I think, was not correct. Because I know that Len Rubenstein, who's the president executive of Physicians for Human Rights, which is how I got hijacked, kidnapped into this work. And I met with the AMA leadership and the APA leadership in about 2005, 6, 7, where they finally decided to come out and say the physicians would not participate.
So it took that long.
The activities at the black sites started when these men were captured in 2003. And I think that really is not veridical.
That's interesting. Mark, let me jump over to you now, and then I'll come back to our two lawyers on the panel. Mark, for of all the many things you've done, the most relevant here is that you were deputy commander of the DoD's Criminal Investigative Task Force. And you were right there on the ground at Gitmo when and tasked with conducting interrogations that, in fact, you couldn't conduct, given what was going on. Can you describe a little what that was like in the early days and how you slowly started to realize what was slowly or quickly started to realize what was going on?
Sure. Well, first, in full disclosure, during this report movie, I did talk with Scott Burns and give him some information. I also met with both Dan Jones and Dianne Feinstein a few times before the report was released, as well as walking the halls of the Congress with Alberto Mora, trying to encourage the release of the report executive summary. I think we need to be clear that over 6,000 pages were written. 500-something pages have been released with redactions, so it's much broader and deeper and more brutal than the public yet knows. So what was happening? I was in the Department of Defense, and I was tasked with bringing terrorists to justice. So President Bush decided to use this military commission process, and that ball landed in my lap to create a task force and investigative capability prior to having prosecutors or defense counsel even assigned or named, prior to us knowing what the rules were, what the offenses were, what the elements of the offenses were. So it was shortly after the invasion of Afghanistan when we started to try to determine what are we going to do with these folks, and it wasn't until John Walker Lynn, dubbed the American Taliban, and David Michael Hicks were captured, that I heard Gitmo for the first time as an alternative. And for me, I was the NCI's Chief of Counterintelligence Operations for the Middle East. And for me, I thought it was an excellent idea because rather than having to send both criminal, and NCIS is both a criminal investigative and a counterintelligence organization. So rather than having to send my folks into harm's way to do these interview interrogations, I thought, well, this would be a nice, safe place to do that. They can get them out of the battlefield. And I had been to Guantanamo in the 90s with the Cuban-Haitian refugee crisis, and I'd been to Camp X-Ray before it became the Camp X-Ray everybody knows about. And I knew there was a break there in the courtroom, and so my thoughts were we'd have a couple of people to deal with, not the hundreds that we had to deal with. But as we were establishing these processes, it came to quite a bit of controversy when Mohammed al-Qahtani, who was supposed to be the 20th hijacker, wasn't able to get in the country, and there were 19 hijackers, and he likely would have been the 20th by our estimates. When we started to look at him at Guantanamo as a high-value target is when the Department of Defense was making a determination that they wanted to utilize the same CERL techniques that the CIA was using. And the one thing that I will say that I think the movie doesn't get exactly right is, and this is part of the narrative that the CIA has put out there, that they re-engineered these techniques. They didn't. They adopted them, technique by technique. You can look at what it's based on. It's based on a study by Albert Bitterman in the 50s about why our servicemen provided false confessions, and that's how they developed the CERL school resistance techniques. And if you look at those techniques, they were just adopted one by one. It wasn't any sophisticated re-engineering. It was just, these modern day equivalents of snake oil salesmen. Mitchell and Jessen just took those, sat and typed them up, and made a lot of money from it. But the controversy really came October 2nd of 2002 when a CIA attorney came down to Guantanamo and he said, if a detainee dies, you're doing it wrong. And he explained what the process was. And by the end of November, Gul Rockman was laying dead in a dark, dank chamber of horrors in the CIA black site. So it didn't take very long for the program to go adrift. And so since that time, there's been an incredible effort to classify, redact, to hide kind of the depths of depravity within this program. Even me, as you know, with Unjustifiable Means, there were 113 redactions. The book was, 8 months under review. Even in the book Interrogation and Torture, I submitted that for pre-publication review, and my chapter in that is redacted. And even I've written an op-ed for CERL that we had hoped to publish in conjunction with tonight and the movie, and I'm still waiting for that to come through the pre-publication review process. So I have a lawsuit with the ACLU and the Knight First Amendment Institute trying to correct this problem within the government where they still have the ability with a person like me to review in advance anything that I am going to put up public.
And in fact, CERL joined in the amicus brief on that lawsuit. So, what was, and your book looks a little like the reports, right, with all the blackouts, but still you managed to tell this incredible tale in the book of this slow dawning realization of what's going on, and your amazement that the standard understanding of the effectiveness of rapport building techniques were not being used. Can you talk about the first moment at which you realized what was going on?
Yeah, it's kind of ironic, I guess, looking back. When Mitchell started Knowledge Works and went to work for the CIA prior to 9/11, and that's in the public domain. Jessen was still working for the Air Force at the time when they wrote, the their review of what they call the Manchester document. And this was really the excuse to inflict torture. The CIA turned to folks who had no al-Qaeda experience, no Middle East experience, no real intelligence experience, and they had them do a review of the Manchester document to talk about how counter-resistance strategies were necessary. And so they created the need that they later, the CIA later, and then the military later adopted, but they worked for the JPRA, the Joint Personal Recovery Agency, and I remember a visit by the Chief of Staff from there, Dan Baumgartner, and he explained to me the CERL techniques in my skiff in my conference room, and I thought he was just trying to be helpful, didn't know I had done this for a living. This is what I do. And said,
indeed, it had great success in very famous other investigations, such as the USS Cole.
Yeah, correct. I was the NCS commander of the Cole Task Force investigating that attack, and I had worked the case on the Blind Sheikh Omar Barakman. So I had been working al-Qaeda since the 90s. And so when he explained that to me, I had a lot of visitors. Everyone wanted to help me. I was the guy supposed to bring al-Qaeda to justice. And I thanked him, and I said, yeah, but I really don't want my guys, I knew what CERL was, I don't want my guys getting dunked and humiliated and laughed at. And, and he said, no, as an interrogation technique. And I said, well, first of all, that's not an interrogation technique. That's a behavioral conditioning technique. Second of all, you just explained to me that it's supposed to inoculate your resistance. So why would I want to do that to somebody that I wanted to get information from? Why would that you do it to people so that they're prepared? I wouldn't want to do that. And so I just thought that they were useful idiots trying to be helpful. And I politely had them leave my office. I didn't realize till the Senate Armed Service Committee hearings that Dan Baumgartner also said he went to another government agency, and he said he went to the DIA. He said he went to the CITF, but I kind of excused him. And so to me it was absolutely shocking that anyone would turn away from. I mean, the FBI had the bulk of the experience. I had worked with the squad in New York that was handling this, the I-49 squad, for a number of years on those cases. But it was shocking to me that others would try to utilize these techniques knowing that it's based on Bitterman's study about false confessions. And so I'm sure Alka will talk about the other shocks that I had through this process is when the FBI turned their back, and I thought they would actually help me stop this from occurring. But when I went to them, they were just passive, saying it's a DOD issue. We can't help you. And we didn't learn till later. I couldn't say till later. Actually, I couldn't say till this summer, and I could just publish an article this week that goes into some depth, so I'm sure she'll talk about this, but that there were actually FBI agents at black sites and were feeding questions and other things. But for years, that was a highly classified matter that I was unable to, I would not be able to talk about at public. But so there were a number of shocks through this process where the FBI actually wanted to render someone out of Guantanamo for torture in another facility. So while I do commend some individual FBI agents for their stance, institutionally, I've yet to see the FBI come out publicly and renounce torture or what occurred in its wake.
And there's been some very recent and alarming reporting about the FBI's, the degree to which the FBI may be implicated here, and I want to get to that in just a moment. But before I do, you were not a whistleblower. You did not go to the press. You did not, tweet out, though there wasn't Twitter back then, what you were seeing. But you did try to work your chain of command to report and to oppose what was going on. And what happened when you did that?
Yeah, well, I was detailed from NCIS to the Department of the Army, reporting to the Office of Secretary of Defense. So I was working operationally with Donald Rumsfeld. And so when I went up my Department of Defense chain of command to the Principal Deputy General Counsel responsible for detainee matters, no one disagreed with me that our practices were better. No one disagreed that our approach hadn't worked in the past, no one was willing to take any action to try to stop it. Their attitude was, we understand, Mark, but, you know, the secretary's approved this. And I would have to say we pledge allegiance to the Constitution, not the Secretary of Defense. And they would tell me, you know, well, it's all secret. And I'd say, well, there are no secrets, only delayed disclosures, right? Someday, somebody will find out about this. And then I went back to my Army command, and they, again, were very sympathetic up through that chain, but said they were unable to sway the Secretary away from this. And I got totally frustrated. And as any leader does, you try to do the job. And I finally went back to my NCIS chain of command, to Dave Brandt, the director, and said, it's beyond my control. I actually thought they were going to kill Mohammed Khatani at Guantanamo. He was getting enemas. He was taken to the hospital. The same practices, and while everyone likes to say waterboarding, there's a lot of uses of water without a board that would replicate this. And so finally, out of frustration, Dave Brandt said, let's take this to Mora, Alberto Mora.
Enter Alberto.
Enter someone who I finally went to, who first was absolutely astounded, said, this is bad legal advice, this is bad law, and I finally came to an official that felt he had an affirmative obligation, as I felt, to try to stop it.
So Alberto, turning to you, you were then General Counsel of the Navy. And is the visit that you had from Mark the first that you had learned about this, or had you already heard bits and pieces of this?
I had not heard about this at all. I met Mark the second day. The first time I heard about any of this was when Dave Brandt, Mark's boss at NCIS, came to me and said, took me aside.
You'll have to speak up a little bit.
Okay. So David Brandt was the head of NCIS, and I should say, by the way, NCIS, starting with David all the way down, is an extraordinarily competent and law-abiding outfit. It was a pleasure to work with Mark and Dave and all the NCIS agents, because there was never any doubt about where the law was and what the right course of action should be for them, for the United States, for the Navy at any point. But Dave Brandt came to me one day in another meeting, took me aside after the meeting was over, and said, look, we're hearing rumors of detainee abuse in Guantanamo. Do you want to hear more? It was a very elegant way to say in or out. You know, it's either way. You know, it's up to you. And my reflex was, if there's any potential illegality anywhere in the Navy sphere, then my obligation as a Navy General Counsel is to try to find it.
Yeah, it's hard to. I think people are having a hard time. Maybe
Sorry.
Why don't you hold your mic a little bit closer? Yeah.
Try to find it as quickly as possible.
Everybody, okay. Maybe IT can turn up our volume a little bit. Yeah.
So I told David, by all means, I would need to know more. And he says, okay, I'll be back tomorrow with my team. And then the team included Mark, who was actually the principal briefer, included the chief NCIS psychologist, who was a very able psychologist and I think a great contributor to the effort, which is interesting to mention, to the role of psychologists. And then they presented what they had seen in Guantanamo. It was a fraction, actually, of what they had seen, but enough to make me understand that something potentially unlawful indeed was going on in Guantanamo. NCIS was concerned about two things. First of all, that the law was being broken, potentially, that the limits on the use of brutality, which actually there is to be no brutality, but that had been exceeded in Guantanamo in ways that NCIS wasn't absolutely clear, because they had not seen the actual interrogations.
So because they had seen the actual interrogation.
Not seen the interrogations, but because people talking in Guantanamo, it's a small village, and so you talk to one another at the mess hall, at the gym, at the beach, in the barracks, and so forth. So people spoke in NCIS, and then NCIS went fishing. NCIS, contrary to the protocols at Guantanamo, went snooping within the other task force.
I like to call it investigating, but you can call it snooping.
So they extracted fragments of interrogation transcripts. Turned out to be Al-Khatani. I didn't know that it was Al-Khatani for years in reality, because there were no names associated with the transcript. And they pushed across the table to me that fragment of the interrogation transcript which dealt with the female guards straddling Al-Khatani, sexually taunting him, putting female underwear on his head, and trying to use sexual humiliation as an interrogation tool. Bizarre.
So hang
Completely
on,
bizarre.
let me just slow you down a second. My guess is not everybody's catching what you're saying. It's so important. You're saying the first thing that you saw was a fragment of a transcript.
Yes,
Did
interrogation
I have that
transcript.
right? Showing a female guard taunting Al-Qahtani.
Correct.
Putting women's underwear on his
Yes.
head. And what else? Who collected that transcript?
Who collected? Mark would know, I think.
Yeah, so JTF, there were two JTFs to start with, JTF 160 and 70, and they combined the two so that they can replicate a program similar to the CIA's. You had to control the conditions of confinement, and so there were issues prior to that because the general in charge of custody was not allowing the intelligence general to do what he wanted, nor were we. And so what they didn't know was that we had access to their interrogation logs. So every day I would get an interrogation, I would get a feed of what was happening inside there. And when things are in the black world, had the CIA briefed me into the program, I would not have been able to go to Alberta. It was their mistake in not briefing me in.
Not reading you in.
Because when you don't know what's there, I mean, I just did my job. So I was taking these logs, and to me, it was a war crime in progress. And so I was sending them back to NCIS, telling people to preserve these records, because if they expunge if I'm fired, if they expunge my emails, somebody needs to have this, because someday there are no secrets, only disclosures. Someone will take a look at this. I thought congressional hearings were inevitable from the day that lawyer came to Guantanamo on October 2nd. It was clear to me where we were going down. So it was pieces of that. And I didn't want to tell Alberta or anyone else about my access because it would dry up if anybody found out. So I was very circumspect in what I knew and would just give him enough to get his interest.
All right, so now, Alberto, so you saw this fragment of a transcript, and what did you think?
Let me add that every time that Mark, for over the last decade, every time he speaks, I learn something new about all this. So NCIS had two concerns. One was that illegalities may be committed.
It's a little bit slower, so.
Illegalities were possibly afoot in Guantanamo. The second concern was that these interrogators were screwing things up. They were incompetent, untrained. They were using brutality for a combination of reasons, but certainly expertise in interrogation was not one of the reasons. The feeling was that these young interrogators were imbued with the cultural message to our media that torture and cruelty is effective as an interrogation tool. So they were doing it, and NCIS was concerned that force creep, a phenomenon known as force creep, was underway, meaning that levels of cruelty would continue to increase until the level of torture was met or exceeded. And in point of fact, a few years ago, I met the first attorney for Al-Qahtani, who stood up in a crowded room and directed him. He said, had the interrogations of Al-Qahtani not stopped when they did, I think my client probably would have lasted no more than a week or 2 weeks and he would have died there in Guantanamo. She was so traumatized by the experience that she left the law and left the United States, for that matter, because she could no longer be involved in these kinds of cases. But nonetheless, NCIS said, we think that force creep is there, we think illegality is there, what can we do about it? My sense there at the end of the meeting was, it sounds like something potentially illegal is underway. I don't know anything about this because, in fact, the Navy was not in the operational chain of command. So neither the Secretary of the Navy nor any of his subordinates were involved in the interrogation activities in Guantanamo or in detainee policy and operations. So, but I felt I had an obligation to look for it. Luckily enough, the only person I knew who might know something about it was the Army General Counsel. And to my great shock, when I called him, I asked him, Steve, I'm hearing rumors of abuse in Guantanamo. Do you know anything about this? And he shocked me by saying, I know a lot about it. Come down to my office and we'll talk.
Right.
Now, if you're an attorney, as you know, you conduct investigations, and 99% of the time, somebody could be holding a whip, but they won't be admitting to any knowledge whatsoever. But to have somebody just admit from the first question that they had knowledge about it was a shock. I met with him the next day, and he handed me a copy of the Rumsfeld Memorandum, which authorized the use of what the memo called counter-resistance interrogation techniques in Guantanamo, and just from just a very quick review of the techniques, which were detainee-specific phobia techniques, waterboarding, stress positions, and other the now similar enhanced interrogation techniques. That coupled with the fact that there was no limitation anywhere in the document, meaning that at no point in the document were the interrogators in Guantanamo instructed that you may apply these techniques, but only until it reaches a level of cruel or inhuman treatment, which of course is the U.S. constitutional standard, the Geneva standard, the international standard on permitted abuses. Those words of limitation were nowhere in the memorandum, so as a matter of legal draftsmanship, the memorandum on its face clearly potentially authorized the application of torture, which was my conclusion within 15 minutes of looking at the memorandum. And then the day after that, I was in the office of the DOD General Counsel, explaining to him what I thought was a clear oversight on his part. It never occurred to me that any American lawyer or any American service member would knowingly inflict torture on individuals. It just never crossed my mind.
So let me pause you there. And again, I don't know if everyone is picking up everything you're saying because it's so important. You're saying that the DOD General Counsel was aware of this.
DOD General Counsel wrote the memorandum, which transmitted the request from the Guantanamo base commander.
That particular memorandum came from DOD General Counsel.
Yes, to use authorization techniques. And he had consulted verbally with the chairman of the Joint Staff and the deputy chairman of the Joint Staff. Both had verbally agreed that the authorization should be given. So DOD General Counsel forwarded it to Rumsfeld. Rumsfeld approved it, and then in his handwriting wrote down below, said, I stand at my desk 4 to 6 hours a day, or rather 6 to 8 hours a day. Why are they limited to standing 4 to 6 hours a day?
Four, I think, yeah.
Something, yeah.
Why is standing, Donald Rumsfeld, again, in case people didn't hear Alberto, I know the echo is a little bit bad here. Why is standing only limited to 4 hours a day? Right. Since I stand more than 4 hours a day, why is DR,
yes.
DR? And this memo is you can pull it up on the internet.
Hey, Claire, can I add something here to put in context? I mentioned that October 2nd meeting. On September 25th, there was a visit at Guantanamo, and it was a visit by Alberto Gonzales, who was President Bush's lawyer, David Addington, who was Cheney's lawyer, Michael Chertoff, who was Ashcroft's lawyer, James Haynes, who was the general counsel of the Department of Defense, right, who was my boss. That's who I was reporting to. And they said they were going down to Guantanamo to learn the status of the military commission cases. And I said, wait a minute, our case agents are in Washington, and I work for him. Why would he be going to Gitmo to get status of cases when the case agents were there? So I went down to head those attorneys off because I was afraid that the general down there was going to try to convince them that he needed to torture. And in hindsight now, I think that was the green light for him to do so.
That's exactly
some
what
of
happened.
the most senior lawyers in the government. But at that time, I had no idea that these were sanctioned by the White House. I thought this was some hapless people who just gone astray, and they were believing a lot of lies the CIA was telling about how effective it was. But I had no idea that it had gone all up to the White House at that point.
Now, flash forward to Alka, who got involved in these cases with defense teams in 2015. And you have been so deeply involved in every twist and turn of what has happened down there since 2015. What is the biggest challenge that the defense teams face? And I also want to ask you, what's the biggest challenge that the prosecution faces in bringing these cases to trial and moving them along, since people have been there for many, many, many years, and we have yet to see a single defendant actually tried by military commission now.
Well, I think we, this is on, I think we face the same challenges from different angles, and it's the torture and it's the cover-up. And so the torture affects us because, number one, my client, Amar al-Baluchi, is one of the 9/11 defendants, and he was tortured for 3.5 years continuously at CIA black sites. There are several results of that, right? The first is that, of course, he's extremely damaged from that torture. And so it is a constant sort of maintenance of Mr. al-Baluchi as we have moved very, very slowly to trial, and trying to build his defense with someone, someone who does not have, his memory is fractured because of the torture. He is physically and cognitively damaged, as Dr. Zanakis knows, because Dr. Zanakis is a consultant for our team and has met with Mr. Albalucci several times, more than several times, I should say. But so that's one of our challenges. Related to that, to the torture, is the discovery, right? We have top secret security clearances. We have the same security clearances that the prosecution has, the rest of the government officials have who handle this information. But because the Military Commissions Act is specifically drafted to allow the prosecution to cherry pick what they give us and to summarize or withhold certain parts of the evidence. So the report is a great example of this, right? The report is classified at the top secret level. It still exists. Several copies still exist within the federal government. The prosecution has been to the Senate buildings to read the full report, but I have access to what you all have access to, which is the redacted classified or the redacted unclassified summary. I know that there are chapters on Amar in that full report, and I cannot get to them. What they have given us instead are summaries of some of the underlying documents that they believe are relevant to the case, which is completely, for the lawyers in the room, completely a backward standard, especially in a capital case. I decide what's relevant to my client's case, not them, but that's how the statute is.
So I assume you have, done somersaults to try to get your hands on that report. What efforts have you made, can you make, and what's the argument for that you get back for not releasing it to you?
Well, and so before I go into the efforts, I want to, the reason this is such a good example is because this is the prosecution has the same sort of problem. They're not the classification authorities. The CIA are, right? And so while the prosecution will stand up and defend these policies, obviously because they have to as government officials, they're taking their orders from Gina Haspel, about what they can and cannot give the defense. And so what we've done is, as far back as 2013, we filed a motion for the report. In 2014, when the executive summary was released, we filed, follow-up motions for the full report. In 2017, Senator Feinstein wrote a letter to the chief judge at the time of the Military Commission saying, you should give the defense access to the full report. My opinion is that this report belongs to the executive branch now. It does not no longer belongs to Congress. And the government's argument, the government meaning prosecution, Department of Justice argument is, this is not our decision to make. It still belongs to the Senate. It still belongs to the Senate, and it is in the custody of the Senate Intelligence Committee, which is under the control of Mr. Burr, Richard Burr, at the moment, who does not want to relinquish the report.
But does he have the ability to release it to you?
Yes.
And though the CIA has something to say about that, I take it.
The CIA technically doesn't have control of
over the document.
According to their own arguments, they don't have control of the report anymore. Control of the report is vested in the Senate Intelligence Committee, and that's where the fight is. The Senate Intelligence Committee, at least under Senator Feinstein, said, we relinquished it. We gave it to the executive. It is now for the executive, you fight with the executive, right? But while Senator Burr is in charge of the Intelligence Committee, he hasn't taken a position outwardly either way but he does have physical custody of the report. And should he or his staffers choose to give us access, we can go over, I could be at the Hart Senate building tomorrow reading the report. I have the requisite clearances to do so.
But why didn't Dianne Feinstein then release it to Gitmo defense teams when she had the power to do so?
So at the time, I think the biggest, but this is going back to 2014, and if you recall the timing, the executive summary was released very, very shortly before Senator Feinstein lost her position.
Her position, right.
Committee. And so the focus at that point was just getting whatever they could into the public domain. Which is why we immediately sort of filed pleadings to say, hey, look, the public now has this 500-page summary. Why can't we see the full report with our clearances? Which is what we did. But at that, by the time that happened, it was really just a matter of a couple of weeks. By the time that happened, we no longer had Senator Feinstein at the helm.
Okay, so now, go back to my question. What is stopping these cases from going to trial? Now, we're supposedly going to see a trial in the 9/11 cases and al-Nashiri?
Well, Nashiri is very much up in the air.
Okay.
But in the 9/11 case, and I can tell, I'm happy to talk more about Nashiri, but obviously I'm working on the 9/11 case. Our new judge, we've had 3 judges in a year and a half, and our new judge has set a trial date of January 2021, so about a year from now. We will see if we get to that trial date, but what has taken so long is we've been in pretrial hearings for now rounding on 8 years. It will be 8 years in April. And the reason for the delay is because from the beginning, from 2012 until May 2018, April 2012 to May 2018, we filed hundreds of motions saying, give us discovery on the black sites. Because this is the center of the defense, as you can probably imagine, right? Our argument is that the primary evidence that the government wants to use to eventually execute my client and the other 9/11 defendants is torture acquired. It is torture acquired evidence. And in our court system and in our justice system, you cannot use that evidence. And so we said, give us evidence about the black sites. And they have opposed almost every discovery request we have filed. They have refused to produce things. The release of the SSCI report sort of opened the tap a little bit. The SSCI executive summary, excuse me, opened the tap a little bit, and they started then to produce summaries of some of the underlying documents, as I mentioned. After that, so that was between about 2015 and 2017, we had 2 years of slightly more useful discovery, but still with things like dates removed, right? So I would get from what you know, Alberto has seen some of the interrogation logs. You've seen the interrogation logs. Mark, you know what they look like, right? It says, you know, there's a date and there's, you know, the detainee and the questions asked and the back and forth, right? That's an interrogation log. And you can look them up. You can find the Katani logs on the internet. What I get is a maybe half-page summary that says, in mid-2003, Ammar al-Baluchi said X about al-Qaeda, right? That's it. I don't have a date. I don't have what they were doing to him at the time. I don't have who was in the room at the time. I don't have where he was. I don't have his medical condition. Nothing. So
you have no way of calling witnesses
exactly.
to substantiate that statement. You have no way of
exactly
addressing the context.
No. I mean, and it's all self-serving summaries. And so for about 2 years, that's what we were getting. And then we said, look, part of our argument as well is the FBI. The FBI reinterrogates these guys when they arrive in Guantanamo after years of interrogation at these black sites. They arrive at Guantanamo in September 2006, and within a few months, they're again interrogated by the FBI in what the government has masterfully marketed as clean team statements. The FBI was the clean team. Mm-hmm. And we said, there's no way they arrive at Guantanamo and the FBI doesn't have any idea what they've said in CIA custody, right? Like, that doesn't make sense. Clearly, they must have some information from their years of interrogations at the CIA. And there was a long sequence of events, but essentially in May 2018, 6 years into pretrial hearings, when we've been asking, the government has said, no, there's no connection to the FBI, we're not giving you any information about the FBI. The government comes forward and says, so we may have something that we might give you about the FBI. And it was only because a previous FBI agent who was there testifying about another thing entirely, who had interrogated Mr. al-Baluchi at Gitmo, slipped up and said that she had had access to CIA documents before she interrogated Mr. al-Baluchi.
So just make clear, why do we care about getting to the bottom of the FBI's role for purposes of the case? Of course, we, the public, care about finding out, but why is this so important for your case?
Because if the FBI had knowledge of all we suspected was that the FBI had knowledge that Mr. al-Baluchi was tortured while being asked these same questions at the black sites. And so if they knew that he'd already been asked these questions while being tortured, then the statements that he made to them were potentially tainted.
Tainted as
well.
Now,
what we found out was it was actually far worse than that. The FBI had actually been, these same agents who interrogated Ammar in 2007 at Guantanamo had been sending questions to the black sites for the 3.5 years he was in CIA custody. The same agents, and had been receiving the answers back to incorporate into the 9/11 Pent Bomb investigation. And so then they stood up and said, we are the clean team. We are only relying on the Pent Bomb investigation to ask Mr. Al-Baluchi these questions. Pent Bomb investigation that incorporated all of that torture evidence.
So what's extraordinary is, I mean, the movie reveals an enormous amount that probably most members of the public don't know. But the movie itself, as of the time that it was finished, this stuff about the FBI hadn't come out yet.
It had not come out. And, you know, I will say Dan Jones is a friend and an absolute hero, and what he and the Senate staff did is extraordinary with this report. But I have never fully understood, to this day, why the FBI's role was so excised from the executive summary. And I will say, you know, they use Mr. Soufan as sort of the hero of the story, and I take great exception to that.
Oh, that's very interesting. That's very, very interesting.
Mr. Soufan is going to be testifying later this spring.
Now, I understand that Jessup and Jessen and Mitchell will also be testifying next week.
Yes.
Can you just tell us a little bit about how he got called, what they're testifying for?
Of course. And so when we started to receive all this information about the FBI connection to the black sites, we filed a very, very large motion to suppress the FBI statements last year. And as part of that, the judge ordered witness testimony. And the government agreed to produce, and I want to just actually make a quick note about this. The government agreed to produce a certain number of witnesses, 2 of whom were Mitchell and Jessen. One thing that I just want to put out there, because this is going to come out next week, is Mitchell and Jessen are very much the face of the CIA torture program. And that is very much by design, right? Now, Mitchell and Jessen were very, very involved, as we all know, in the development. They developed the techniques, but they put the techniques forward as a way of torturing these men and getting information from them. But the program itself, the people who tortured most of the men, certainly the 9/11 defendants and most of the other so-called high-value detainees in CIA custody, were CIA personnel whom the CIA has been very careful to cover up their names. I don't have their names. I have unique functional identifiers for each of those people who actually tortured the high-value detainees. So I just want to be, clear about that Mitchell and Jessen are being very much put forward as the face of the program, while there are 50 to 60 other people who actually who tortured many more people than Mitchell and Jessen did.
Now, one of the things that I want to ask about is what we would expect them to say and what their role would be, because they're not being grilled as defendants or anything, or they're not really being put on the hot seat. But what exactly is the purpose of their testimony? Steve, maybe you can say a few words about that, because the psychological aspect of what they're likely to testify to is a little bit unclear.
I've not talked with Alka exactly how that's going to unfold. We will both be in the courtroom. I think what is as the focus is back to the idea of the state of mind. And if you understand, if we think of this as an individual subjected to this condition with these environments and with these particular stimuli or triggers, and that there was behavior and statements made under the conditions that Mitchell and Jessen operated, then what is the legacy of those conditions later on? Either when they've been interrogated by other individuals or encountered other government officials trying to get that information. As a practitioner, to have an individual who has been subjected to 3 years of such harsh conditions and to have a state of mind induced, one would absolutely expect for that to continue for quite some time, if in fact not for the rest of that person's life. And that there would be any number of conditioned and unconditioned stimuli that could bring them back into a situation where, in fact, they did speak or conducted themselves when in a situation of torture.
Well, don't Justin and Mitchell have a vested interest in denying the long-lasting effects of this treatment? Wouldn't you expect them to try to establish that, even though it's not fully germane to the...
I would, absolutely. Right? I mean, because they did this under the idea that there was not lasting harm.
Right. Alpha?
Well, the caveat to that, you're absolutely right. The caveat to that is that, and if you've read Dr. Mitchell's book, you'll know that he gets very, very defensive after the first couple of chapters. He talks in glowing terms about how he conceived of this program, and he and Dr. Jessen conducted the interrogations of Abu Zubaydah. And then after you get past those chapters, he talks about how the program was basically taken from them, and it fell into this sort of abuse at the other sites. It was the other people who were abusive of other detainees. And he and Dr. Jessen have sort of, well, certainly Dr. Mitchell more publicly, have sort of said, look, like the Senate report names us. It doesn't name any of these other people who did all of these other things. And so I think that, I think that's a story that we want to tell. We want to make it clear that this was a broad program involving a lot of people who did a lot of bad things. It was never, just 2 people in a room or just 4 people in a room at Gitmo. It was an agency-wide, a government-wide program.
So I want to ask one really important question and then open up to our audience, because I'm sure they have lots of questions too. And this is about the effectiveness point. One of the things that the movie really sought to stress is that harsh interrogations using these methods are not effective. That is a really, there's so many layers to that issue. And one of the things that I think the film did so nicely was to bring out the vested interest that the CIA and possibly the government more generally has in claiming effectiveness for these techniques, and as represented in, for example, Zero Dark 30. Is there any worry that by taking the stance that torture produced the confessions, and therefore we have a basis for suppressing the confessions, that you are actually sort of playing into that narrative? That you are allowing the suggestion that, hey, it was, if these confessions were produced under torture, then maybe the torture was effective in producing them?
Not at all, because there's not, that assumes that number one, that they are in fact confessions, the statements made, and number 2, that they're accurate, right? And unfortunately, I don't think the government can prove either one of those things. It's for them to prove, not for us to. But they can't. And the record is replete with information that we know that was demonstrably false, not just from Ammar, but from Mr. Mohammed, from Mr. Benatash, from Mr. Nashiri, from all of the defendants. Some of that is in the 500-page Senate report. Some of it has come out through the Military Commission's litigation. But there is no question, I think what has actually been proven over and over and over again, that the reliability of the information that was gotten is just completely, there's no reliability.
So that by showing that the confessions were gotten under torture, you're in effect showing both that they're suppressible and that they're unreliable.
Exactly.
Let our audience in, and I have so many things that I want to ask. Alberto, did you have something you wanted to add on that?
Yeah, I think just to touch on the question of effectiveness, we've discussed about this before, but the issue has to be posed, effective for what? And most of the time we talk about effectiveness, we're only talking about the tactical effectiveness of torture, but there are strategic dimensions to this thing. We've constructed a nation based on the concept of rights, and we can torture anybody the way we torture these individuals. It's because that inalienable right doesn't exist. The United States is now claiming the ability to make a decision whether they can apply cruelty to any individual as a policy matter, it's no longer a question of rights. We constructed an international human rights system which also has the prohibition against cruelty and torture as one of the foundation pieces to it. And again, what the United States has done by both applying the torture and not holding ourselves accountable is eroding that very architecture of human rights that has been effective in creating a better world and a better nation. This is why this continues to reverberate in this country, because we have not held ourselves accountable for having done this, eroding the basic prohibition against torture and the rights that everybody should hold.
So the first thing that happened, of course, when detainees started to be brought in, or even earlier, even before, is that Rumsfeld took the position, supposedly advised by his lawyers, that the Geneva Conventions did not apply to these individuals. And by taking that stance, and then as Alberto, you're suggesting, the lack of accountability for the conduct that then occurred under that supposed legal framework, we are in effect still stuck with that approach.
Yes, as evidenced by the litigation in Guantanamo. We've been litigating, as Alec has pointed out, for all these years, the issue of torture.
And it's important to see here that you don't have to be sympathetic to these defendants to see what a deep problem this is, because the prosecution can't get a conviction either, right? And so there they languish.